I'm back. I'm chilling, man. I'm doing well. I think we reached a kind of a landmark. We reached over over 250 likes. I think it's about what 900 and I'm sorry, 256 exactly. But let me see. It is 256 follows and 255 likes. So yeah, we reached the landmark. Over 250 likes and follows. So thanks, guys. Please um, like and share and tell more people about us. We did. Um, well, I wanted to read a statement from Chief Justice Roberts. Is I'm not sure when you heard about the leak. I'm sorry. There's a echo. I was playing a stream on another page. Okay, but So yeah, I think this leak first came about was made public last night. That's when I first got a notification on my phone. And Chief Justice he put out a statement. He said, "To the extent this betrayal of the confidences of the court was intended to undermine the integrity of our operations, it will not succeed. The work of the court will not be affected in any way." So, and also he said that I have directed the marshal of the court to launch an investigation into the source of the leak. And he made it pretty clear that this leak that leaked opinion doesn't reflect an official decision from the court. Like, as in, I guess their minds are still, being made up somewhat. That's almost what he suggested, but I mean that's kind of hard to believe considering there's a 98-page draft of an opinion as looks completely written. So yeah, he, yeah. This opinion, they weren't expecting a decision from this opinion until at least by like the end of the summer. So yeah, this leak, it to me it seems politically motivated to rile people up, to try to stop it. But anyway, I digress. That's not exactly what we wanted to talk about. Um, you, I was reading when I first opened the case. When I first opened up the initial draft opinion, I wanted to be sure that they weren't. I guess the press wasn't misinterpreting it. and it starts off pretty pretty clear, not prone to much interpretation. It says, "Oh, that Roe and Casey must be overruled." And it says the Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty. So like, I like to start on the 14th Amendment because that's really where the right to abortion is really embedded. And so, just a brief history. It's one of the they call Civil War amendments. It along with the 13th, 14th, and 15th amendments, they all came about in the same year, like 1865 or 66. One of those. It was right after the Civil War, and so um, the 13th Amendment outlawed slavery. 15th gave blacks the right to vote. 14th, that is the very interesting one. And what it did was it it prevented states from making second class citizens. It says that any person born in a state is a citizen of that state and a citizen of the United States. That's essentially what it said. And the goal was to make blacks. Um, as- they were in a very precarious situation right after the Civil War, been freed, um, still, however, still uneducated, no marketable skills for the most part, and so this amendment was to give some sort of protection from them in a way. And fast forward about 50 years, you have something called the incorporation doctrine, right? And which is a principle extracted from, or I would say extracted from, and in Justice Alito's case, who wrote the this majority opinion that's just been leaked, he would say it is it's I guess it's the eisegesis. It was read into the text that the principle of substantive due process, or what they call is the incorporation doctrine. What it does is it takes several several amendments from the Bill of Rights and apply them to states. Because initially, for instance, like the Second Amendment, that only applied to the federal government. The federal government couldn't take your guns, but if the state of Virginia wanted to outlaw guns, they could. Right. Same with the Fifth Amendment. The state of Virginia didn't have to, had no constitutional obligation to guarantee due process or free speech, because the First Amendment, the Fifth Amendment, etc., applied to the federal government, not to the state government. The 14th Amendment put this legal bubble around people who were born inside the United States, and it said that since you are born inside the United States, you are a citizen of the United States, and you are guaranteed these rights, and no one can take them from you. So since you were born within the United States, according to the 14th Amendment, you have a right to free speech, and no one can take it from you, whether it's the federal government or the state government. So you using that go ahead. Yeah. Could you check the audio? Because I was looking and I don't hear anything from a stream that I'm watching. I don't hear. Yeah, I don't hear anything. Either one of us. Do you hear anything? Okay. Hmm. Okay. Well, if you can hear us, then we can be heard. Can you hear? Can't hear you. Okay.
Okay. I found the issue to the error, and it should resolve
Okay.
itself. Yeah, so now I can definitely hear myself. Okay, that's what's going on. So we couldn't hear me. Apologize for
Gotcha.
all of that. However, welcome everyone. We're basically talking about the current decision that is in court under Samuel Alito to potentially overturn Roe versus Wade. And we were just having a little bit of discussion about how um, essentially humans were afforded inalienable rights from the federal court, which gives you certain rights, and then the state, which is then required to also afford you those rights. That's kind of where we were talking about. So if you didn't hear my side of the argument, all I was just doing was confirming what Gio was saying, is that these inalienable rights that we have, the federal government affords to every United States citizen, and then the state cannot then encroach upon them with their laws and regulations. Although they may not perfectly align, they may not necessarily even go hand in hand, you have inalienable rights that are afforded to you by the federal government that the state cannot then encroach upon. So, as you were mentioning, some like the Bill of Rights, if you will, the first 10 amendments of the Constitution are federal rights that you get from the United States government, generic. However, they've also now been applied to the state itself. So the state that you live in, although not the federal government, also has to afford you these same rights. So that's all we were just talking about, and I apologize for the audio issue.
Yeah. And so, fast forward a few more years, you have not only do you have the courts applying rights that were initially well, I guess protections that initially only applied to the federal government, to the states. Then he started applying, I guess, what Justice Alito would argue, new rights, or rights that did not exist in the Constitution. Okay, and I think one of those rights, the foundation of this really started with Griswold versus Connecticut. They know the right to privacy. It was about people using birth control, and it pretty much said that the government had no right to infringe and what's going on in someone's bedroom. It's their right. Government has no say in it, and that's kind of the same legal justification that's used for Roe v. Wade. Is the woman's right to privacy. That so the state has no right to even uh, rule over it, because it's a private issue concerning just the woman's body alone, and it's up to her to make that decision.
Yeah, so
Now,
obviously this just goes back, as you were mentioning,
go
to
ahead.
the 14th Amendment. So essentially, this is where, like, we kind of have to play this connect the dots, if you will, because there are certain rights afforded by certain amendments, and then there are obviously laws that go along with that, or that use things like the 14th Amendment to establish precedents in current legality, and that's essentially what Roe v. Wade did. So basically, you have a right to your own person, therefore, the act of abortion, which is performed by that person, or on that person's behalf is because you have a right to bodily autonomy.
Yeah, and so I was trying to find the one of the quotes. I thought I had shot it. I guess I didn't. Man. Oh, so anyway, so if you read the opinion, well, there's a lot of confusion going on. Like there's a lot of people that I've seen online thinking that this ruling would completely outlaw abortion within the United States altogether. It was just it would just be completely illegal, and that's not what that's saying. That's not what this is saying. It's saying that it is no longer a a federal right that is protected with substantive due process. Now it is up to the states to decide. And he argues, I can't find the exact quote, but Justice Alito argues that because this is such an important issue, that it ought to be left for their duly elected representatives to decide. Essentially, I think he uses the word democracy. Now, like,
Yeah, I know exactly what you're talking about. In fact, we were talking about it right before the episode started. And
yeah,
you're right. It does use the word democracy. I'll see if I can find that for you.
it, the part about that quote that really bothers me is that you know, for one, I guess there's two parts. For one, if something's a right, then it ought not to be left to the discretion of the majority. You know, like for instance, I have a right to um, eat spaghetti in my own home, right? So it shouldn't be up to the democratic process to decide whether or not I'm afforded that right. Because like if it's my house, I'm eating my spaghetti, then I have a right to do it. You know, like or if I a right to practice any sort of religion, that stuff like that shouldn't be left to the whims of the majority. That if they're rights, then I should be able to do it, regardless of who agrees or disagrees. Like even if the entire world is against me, like it's still my right.
Yeah, it
So
shouldn't come down to a matter of
I,
opinion or popular opinion or even like a majority rule kind of thing. If you have
yeah,
this right, and that's where I was referring to inalienable rights earlier. If you have this right, which you have a right to in your own home consume food that you own. If you're consuming food that you stole, then you've stolen something. That's because you've essentially taken someone else's property. That act in and of itself may not be right, but if you legally own the spaghetti or anything else in your home, you have a right to essentially do whatever you want to with it due to like property laws.
yeah. And so from what I see, now granted, I didn't read the entire 98-page opinion. So and so there's a lot to sift through. I was skimming through it really quick, about an hour or so before the show. But I don't see where he made the argument that it's not a right. What he said was because of how important this issue is, it ought to be left to the people. Because it's a right. So I guess maybe you can argue that if he's saying that it should be overturned, so should all the rationale. But I would like him. Maybe he does. Like I said, I didn't read the whole opinion, but I hope that he discuss whether or not abortion is a right or the right to privacy is a right. Because if so, giving it to the states to decide doesn't make a lot of sense here, and it really bothered me, especially when remember we were talking how he mentioned Plessy versus Ferguson, And so, for those that don't know, that's the case that established separate but equal. It legalized discrimination, like racially based discrimination, like Jim Crow laws, etc. And it seemed like, from what I was reading, it seemed like he mentioned that because he was afraid that his rationale for overruling Roe v. Wade could be used to overrule Brown versus Board of Education, which is what outlawed Jim Crow.
Right. And
So
I knew where you were talking about in the document well enough that I was able to find it. So I want to read it to you, and I'll read it for the audience, and if I can tell you where it's at if you want to go read it yourself. On page 34 of the 98-page document that was released by Samuel Alito, I'm going to read this as an exact quote. Quote, both sides make important policy arguments, but supporters of Roe and Casey must show that the court has authority to weigh those arguments and decide how abortion may be regulated in the states. They have failed to make that showing and thus return the power to weigh those arguments to the people and their elected representatives. End quote.
yeah, and so yeah, I don't like that, man. You don't let the majority decide the rights. And like I was saying, it sounds like he's afraid that his argument for against Roe v. Wade could be used to justify discrimination laws. Hey, just let the states decide whether or not we want to discriminate against minorities. And he he prefaced it by saying, well, it was a, I thought it was a preface because what he said was that Plessy versus Ferguson should have never happened and it was immoral. And I thought this was a preface and he was going to get into the meat here. But then he stopped talking about it. So he just says Plessy versus Ferguson is immoral and it doesn't apply here, but he doesn't give an explanation why his rationale for leaving leaving abortion to the discretion of the states. He doesn't explain why that can't equally apply to segregation laws. And I mean, I get it. I mean, I'm a libertarian, and one one thing that libertarians, they kind of stress, they like smaller government. So since states are smaller, they tend to do things more efficiently, and there seems to be a little more protections in a way. But if you read history, the states have the states tend to not protect human rights as well as the federal government. You know what I mean?
Well, yeah, I mean, we
You
can
know,
obviously point to the mid 1800s to kind of go to point to that exclusively, and throughout American history, specifically throughout African American history, leading up to the Civil War, and then even in post uh, Civil War era or the antebellum or the postbellum period, which invited things like Jim Crow law and so
exactly.
like
So
other
so
things like it seems that when you leave the states to decide at least at the level of individual human rights that the state doesn't seem to have people's best interest at heart as much as having their own interest at heart for what's best for them in a particular scenario.
yeah, so like I mean, think about this with with slavery, for example, that was protected by several states. It was a federal law that got rid of it. Black codes that came right after the Civil War. I was protected by several states, and it was federal law that got rid of it. And then Jim Crow, like a slight improvement over black codes, protected by states. And it was, of course, there was Plessy versus Ferguson. Like in that instance, the federal government protected them, but then they came back, 60 years later, and got rid of it.
Yeah, with Brown versus
So
Board
I
of
mean,
Education. So
yeah. So I mean, when it comes to civil rights, when it comes to like protecting um, minorities or just when it comes to civil rights, from at least in American history, the federal government tends to do a better job than the state government. So I'm not sure how wise it is to to leave it up to them. I, what's likely to happen is you're going to run into bubbles, whereas it's going to be legal in this state and illegal in another state. I mean, that's probably what you're going to run into, and you could argue why can't someone just, like, for instance, like, let's say if abortion is illegal in Virginia, which is possible because Virginia goes red or blue. I mean, depending on which year it is. So I live in Virginia. Why can't I just travel to DC, which is like almost always blue, and get an abortion and come back? Well, a lot of the states are already have what they call trigger laws. So as soon as this decision goes into effect, it would legalize this law, and it would make it illegal for someone to leave the state to get an abortion performed.
Yeah, and this kind of opens a can of worms to just, and I'm gonna use and something we have up on the screen right now is WHPA, which, if you're not familiar with the term, it's the shorthand of the Women's Health Protection Act of 2021. However, it goes even deeper than that into the problem, one of the many problems with how healthcare is treated in the United States currently. Because not only is there trigger laws that would essentially prevent people from going from one state to another to do something like an abortion, but it also, like, if you have, for instance, insurance through the company you work at, chances are you'll be outside of the insurance footprint, and it would probably cost you a small fortune to go have any sort of medical procedure done in any other state because you're now outside of that insurance footprint. But, like, you see what I'm saying? Like, it's just kind of this domino of towering effects to kind of prevent this kind of stuff from happening once you lay the foundation for it. And I'm not suggesting anything like even suggesting or pretending to suggest something like universal health care or anything like that. I'm just saying that when there's no standardization, for instance, when there's no federal guidelines for states to follow, states kind of treat people how they want, as we were just talking about. And that can also impact how people's insurance and healthcare and other things besides strictly abortion, but that's what we're talking about here, can be impacted by, because you go outside of your footprint and all of a sudden your insurance doesn't work because the insurance isn't accepted in this state, or because this particular procedure isn't, whatever, by your own private insurance, because there's no standard of regulation in healthcare from state to state through federal government. So if you think it's problematic with the current regulations we have, by removing these regulations, it's only going to get worse. Like, you see what I'm saying? Like, it again, not calling for anything like universal healthcare or whatever, or, by any means necessarily more government restriction. It just seems that the especially when it comes to cases like individuality and individual rights, when you start laying the groundwork for, we'll just let the states decide, it seems that the states kind of go against you because it's all about what's best for the state in that particular moment in time.
Yeah, I mean, if you look, I mean, that was the reason for the Civil War amendments in the first place, right? It's because, like, they had a 13th Amendment. It's because the states wouldn't afford blacks the right to vote. They just wouldn't do it, right? Well, not all the states, but like southern ones, right? They just wouldn't do it. Same with them; they wouldn't grant them citizenship. That's why you had the 14th Amendment.
Yep.
And I think I said I think I just said the 13th Amendment gave blacks the right to vote. I meant 15th, but I misspoke. But you know what I meant. But I mean, but that was the purpose of it in the first place. That like states really can't be trusted to protect this. I mean, I don't think you want to give states the you don't want rights fluctuating with the whims of the majority. That is not
And
that is
just to
not
kind
ideal.
of really drive the point home, if I may, and to really put things in perspective, is that if you look at historically, when states were given the right to, or when states were deciding individual human rights, what did you notice would happen historically in instances of this happening before the federal government said, okay, this is an actual right, and that's something that we discussed. What does it mean to have a right to do something? Well, if every human being is indeed a human being, and every human being born in the United States is a United States citizen, but your state says that you are not a human being, or you are not a United States citizen, then you probably don't want to live in that state. And that's exactly what was happening with historically in the southern United States when it came to slavery and slave owners.
You
I
know,
mean,
you made it so. Think about this. So remember, what he says in opinion. I can't find the exact quote, but he was talking about how contentious the topic was, and he was saying how I think it was on page 39, but that you had referenced earlier. He was talking about how contentious the abortion, issue was, and that the Supreme Court, they I guess they usurped the authority of the people to decide this contentious issue for themselves by saying it's a right found in the Constitution, right? Think about how much more contentious the topic of slavery was.
yeah, I mean,
I mean, they literally had a war over it,
yeah, I mean, we're
right?
talking about
So
we're talking about things like personhood or and identity and people literally being labeled as not human or not citizens, and then we're granting them a percentage of humanhood or personhood or citizenship by saying, oh, well, like things like the 3/5 law. Like you're literally taking some of these contentions that are just looking back through the lens of history and modernity. It's so apparent all humans are human. It doesn't matter what tone their skin is. Every human should have the same basic human rights, no matter what their color is, no matter their skin tone, no matter, whatever. And if you're born in the United States, in any state, you should still be afforded those same rights to every person born in any state.
so I found the quote that I want or one of the quotes that I wanted to find. Check this out. It says Roe, Roe v. Wade, was on a collision course with the Constitution from the day it was decided, and Casey versus Planned Parenthood, perpetuated its errors. And the errors do not concern some arcane corner of the law of little importance to the American people, rather wielding nothing but raw judicial power. It says the court usurped their power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. Casey described itself as calling both sides of the national controversy to resolve their debate, but in doing so, Casey necessarily declared a winning side. Those on the losing side, those who sought to advance the state's interests and representatives, I'm sorry, um, those who sought to advance the state interests in fetal life could no longer seek to persuade their elected representatives to adopt policies consistent with their views. So now, this is kind of like what I was talking about earlier. I don't see how this couldn't equally be seen with Brown versus Board of Education. Isn't that a usurpation of the state's power? I mean, because the Constitution it makes no explicit uh, guarantee of like equality. I mean, not outside of procedural due process. like the Fifth Amendment and stuff. But like, I mean, outside of like the criminal justice system, but it makes it makes no explicit. Um, it doesn't explicitly address the, I guess, the legality or morality of discriminating against minorities. So why couldn't his same rationale be used for Brown versus Board of Education? Hey, there's just the court usurped the power of the people, and the people didn't no longer had the ability to, to try to convince their representatives to make laws that reflect their opinion, as in don't allow black people into certain stores and stuff.
Yeah, so
I don't see where this is addressed. And like I said, he kind of predicted this objection, but he doesn't make an argument. He
yeah,
just
in fact, I think his argument is kind of fundamentally flawed, because I would argue that people who defend abortion in general aren't reaching out of nothingness. They're basically claiming right to bodily autonomy. I believe that would probably be the basis for the informed person that is pro-choice. They would say that it is a person's choice because of bodily autonomy, and what we mean by that is because it is their body and it is something that is impacting their body, and something in the cases of like carrying a baby, it is something that is either impeding or in fact dwelling inside of their person, right? So like that, the case for abortion come and stems logically and argumentatively legally from bodily autonomy. Just like, if there's like no one can basically infringe upon your bodily autonomy. They can't come and lock you in a room somewhere, that kind of stuff.
yeah.
In
And
on page
that's
33,
what?
I was just gonna quote on page 33. He's referring to the first sentence says defenders of Roe and Casey. It says without the availability of abortion, they maintain, the people that defend Roe and Casey, that people will be inhibited from exercising their freedom to choose the types of relationships that they desire, and women will be unable to compete with men in the workplace and in other endeavors. And then tries to give a juxtaposition of that by saying Americans who believe that abortion should be restricted press countervailing arguments about modern developments. They note that attitudes of pregnancy of unmarried women have changed drastically, and that federal and state laws ban discrimination on the basis of pregnancy that leave for pregnancy and childbirth are now guaranteed by law in many cases, and that the cost of medical care associated with pregnancy is covered by insurance and government assistance. I think he's really missing the point here.
Yeah.
Because he's not making the argument from bodily autonomy, he's making it from the standpoint of relationships or competitive and workplace like competition. And that's not really the standpoint of most people that are pro-choice.
Yeah, not at all. Like all of those are just consequences of it. But that's not the basis of their argument. The basis is bodily autonomy.
And then he
and
like,
hey, if you take that away, then all of these things could happen. But that's not.
And then he kind of shoots himself in the foot and says that federal and state laws ban discrimination based on pregnancy. Well, it's thankful that those federal laws exist. These federal rights that you have say that you can't be discriminated against for things like the color of your skin, the religion that you adhere to, or whether you're pregnant or not. You can't have it both
It raises
ways.
the question: why were those laws enacted at the federal level? Is it because the states failed to do so?
Yeah, I mean, I think it just goes to show there's quite a huge like juxtaposition here, and it seems like he's making almost a straw man argument on behalf of the side of like pro-choice, if you will. It's not really a strong argument by any means, and it's not the argument that even most people utilize. Its consequences of the reactions and actions, and these laws have come about because of these either insufficient state laws and or insufficient federal laws leading up to this, but it's not the source, if you will, of the argument, and it's not the foundation of the argument.
Here's when I, when I was saying how Alito had kind of predicted the Plessy versus Ferguson objection, saying that your reasoning could be used to allow states to decide whether or not they want to enact Jim Crow laws. This is what he says. He says the infamous decision in Plessy versus Ferguson was one such decision. It betrayed our commitment to equality. It was egregiously wrong on the day it was decided. That's it. Okay, yeah, they made a bad decision. Like, how does this? I mean, how does this not apply to your own argument that you're making? You know, I mean, granted, I didn't read the whole 98 page document. I'll go through it later. You know, if this
Well,
is
if it
still
helps,
relevant
I
next
can
week,
tell you,
maybe
I know about where
we
you're
can tackle
reading.
it again at some other later time. But you know, I mean,
I was just
for
gonna.
me, I'm looking at this. It just seems at on a surface level, it seems like some really lazy legal reasoning, in my opinion.
Yeah, so I mean, essentially, and I can tell you because it goes on later in page 36 of this document. It says some of our most important constitutional decisions have overruled prior precedents. We mentioned three. And Brown versus the Board of Education, which is the one we were just talking about, the court
Yeah.
repudiated the separate but equal doctrine, which had allowed states to maintain racially segregated schools and other facilities. In doing so, the court overruled the famous decision in Plessy versus Ferguson, along with six other Supreme Court precedents that had applied to separate but equal rule. So what? I mean, the argument almost seems that hey, we recognize this is either a poor decision or a bad decision, and at state level there was still segregation being allowed, and then at some point in the not too terribly distant future from this decision, there was another Supreme Court ruling that overruled Plessy versus Ferguson, called Brown versus the Board of Education in the specific example, that had a better ruling. I think the argument he's trying to make is that we could potentially come up with a better ruling for like Roe v. Wade or Planned Parenthood versus Casey, but he's not presenting the actual argument itself, and he's not appealing to the like due process clause of the 14th Amendment. He's appealing to things that aren't even the like substantive arguments like we just mentioned, like the competitiveness and versus of men versus women in the workplace. Like
Yeah,
that
that's
doesn't take anything away from human rights. That's not what
yeah, that
the argument is for.
not at all.
So I just wanted to mention that because I saw it at a later point in the argument and I had it pulled up, and I've been, like I said, I've been reviewing the argument, and I haven't read every single word, but I have reviewed in quick fashion, admittedly, the entire document, and I've read a fairly good portion, but without looking at every single reference that it makes, because there's quite a few references to previous legal cases and precedents mentioned at the bottom of each page. But I mean, the first 50 or so pages I've pretty much read well, and the entire document of 98 pages I've at least glanced over, and it just seems it's almost not necessarily an argument from ignorance. He's just strawmanning the actual argument of human rights.
Get this. So here's a quote. He says that the inescapable conclusion is that a right to abortion is not deeply rooted in the nation's history and traditions. Well, you know what else isn't? Equality.
Yeah, equality is.
I mean, like that's like that's don't understand. I'm definitely going to read this entire opinion because
Yeah, I mean,
It's not
so,
making any sense to me.
to be really clear of just how backwards things can be versus how things are perceived is in the Declaration of Independence. We find that all men were created equal, right? That's what we find, and yet
Hmm.
we have several amendments to the Constitution granting things like African Americans' right to vote, women's rights to vote, like things like that. Like why?
Yeah.
If the founding fathers who wrote the Declaration of Independence, so you have like Thomas Jefferson writing the Declaration of Independence, if we genuinely had a historic precedence of this throughout the nation, there would be no need for things like the 15th Amendment. Like it just wouldn't need to exist.
Yeah.
Am I wrong?
No, I mean, no. I mean, you're right on. You're spot on. I totally agree with this.
Yeah,
And I
so
guess I mean, because if
it
he's
just goes
appealing
to
to the
show, like,
nation's history and traditions,
yeah, like
you know,
history and
I mean,
tradition showed slavery and inequality and subservience to for African Americans, subservience to non-landowners, subservience by women. I mean, there's just like pick an era in American history in which we have as much equality as we have now. Is it perfect
yeah,
now? No. Is it great now? Probably not, because we still have huge things in which we have prejudice over, that we have problems with, that we have like legal issues coming up with almost daily. However, is it the best it's ever been? Probably. Especially
yeah,
when
I
you
would
look at
argue
it
it
like
is.
as far as historically, probably. So I mean, it just goes to show like what we're talking about is not women competing against men in the workplace. What we're not talking about is how far states have come to help women who are giving birth to children, as far as insurance or covering government assistance or the ability to anonymously drop off their child at a control center or any of that. That's not what any of like bodily autonomy is arguing. Bodily autonomy simply points out it's your body. You should be able to do whatever the heck you want to do with it. And to straw man that argument by saying, well, historically we don't have a precedence of it, or that the only reason that you're saying this is because before all these laws that came into existence existed, it was harder for women to find somewhere to drop off their child, or harder for them to compete in the workplace, whatever. Like that's you're really just missing a bigger picture here. And again, this is not to say that this particular argument, that this opinion piece, even if it were passed, would automatically overturn Roe v. Wade and automatically ban all abortions in the United States. That's not what's happening. I don't want people to get the wrong idea. That's literally not it. It basically, this opinion piece, if it were to go forth and be voted on in a majority rule of the Supreme Court of the United States, would essentially put back some of the jurisprudence on the states, saying that they have the ability to imply more restrictions than the current federal government allows. So
I found another quote, and it's like right at the end. It says the Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. It doesn't do the same with again back to Plessy versus Ferguson. It doesn't do the same with the Jim Crow laws either. So that's what I'm saying. Like the rationale here, like it seems to be, my opinion, extremely politically motivated here.
Mhm.
Because is legally this is lazy. This is straight laziness.
Yeah, I mean, so
And,
that's where like we have these few basics up on the screen, and we haven't specifically like gone over each one, but we've kind of counterintuitively, but intuitively gone over each one because we've talked about each one of these issues. And it just seems like usually I say, is there a particular topic or anything up on the screen that you want to talk about, and vice versa. It's just that, like, literally throughout the conversation that you and I have had, and throughout just reviewing the document itself, kind of talking about what's going on, we've inadvertently hit every point on the screen, and we still have come to the same conclusion. Like,
yeah.
it's just baffling to me.
Yeah, I mean, yeah, it's bizarre, and that's what like so he mentioned like I said, I don't think it was any accident he mentioned Plessy versus Ferguson because he sees this criticism coming, but this was a very lazy attempt to refute it. I mean, I don't know if you could count this as an attempt at all.
Yeah.
You know, he just said, "Oh, that's immoral," but there's no. I don't see any legal rationale why it can't be employed. And I'm sorry to keep I'm sounding like a broken record here, but I mean just the more that I read into this case because I'm reading like here like live on air, and it, more and more it just sounds like some very I don't even know the word for it. It's just
Yeah, so I think
I
there even goes into it a little bit, and I'll read you this, and you can kind of give me your 2 cents on it because I think it's worth mentioning that it
mhm.
seems almost that there's a mischaracterization or a misunderstanding maybe that Alito has, and I think he's trying to point out he has problems with the procedure itself, the procedures of abortion itself, not necessarily the act of bodily autonomy. And here's where I gather that down
Yeah,
on
he goes
page,
into the trimester. Yeah, I'm
well,
familiar.
not
Go
only
ahead.
the trimester
Uh,
issue,
uh,
but down on page 62, I'll read you this exact quote.
yeah,
Abortion
that's more
is a
from
unique,
Casey. But
yeah,
yeah, I'm sorry. Go ahead.
yeah, even a Casey plurality is recognized. Abortion is a unique act because it terminates life or potential life. Abortion is inherently different from maritable intimacy or procreation. So it it seems that he's got problems with the termination of life or potential life as it relates
That
to the being and how the operation is performed. Whereas
and so
there's a
so
stark
so that's
contrast
some.
between that and like bodily autonomy. I mean, what's your take on that?
I think that's some very sloppy language he's using because he's saying like it deals with the termination of life or potential life. First of all, I'll argue it's not potential life; it's definitely alive. I mean, at all stages, it's a cell, regardless. At all points, it's alive. But life can't whether something's alive can't be the determining factor here. Like I mean, what about when you say like move removing like cancer cells?
Yeah,
Like
I mean, cells are
it's
alive.
alive.
It's just true.
We need to be talking about personhood, not life, because you if you just use life, you can extrapolate that argument and come to some very absurd conclusions. If life is the only barrier here, so if it's life, then the states has the right to prohibit it. Prohibit the termination of life. Okay, cancer cells. What about their living cells from anything like your hair?
Mm.
I mean, and I know that. I mean, this sounds like absurd, you know, examples. But what I'm saying is the rationale for I'm saying the word choice for using life is very sloppy.
Yeah,
I
so I mean,
wouldn't.
we
I don't like that term.
definitely being an option of what he's referring to is in actuality personhood, which is something if you go back and listen to our abortion episode, that's something that we bring up because personhood is what makes a person a person. Life is a defined structure which exists throughout the world, and you could even say things are human given that they are human cells, if you will. They belong to Homo sapiens. So your skin cells are alive until they either die and fall off or they get scratched off or cut. And all of those cells are human. They're all cells of the human body, but they don't get any special treatment as far as if you need to cut into them to remove cancer cells, which are also human. You're not. That's not something you're considering, and you find it how silly that is when you start to make that argument. Like it's not getting any special treatment because it's a human cell.
Yeah,
And
what bacteria?
yeah, bacteria. By the
Take
way,
taking something
there's
to kill bacteria. Hey,
yeah,
that's alive.
yeah.
It's
By
a
the way,
life.
there's more bacteria cells in the human body than there are human cells in the human body. And when you take an antibacterial drug, which kills those bacteria cells that are in your body and that make up the processes which make up your body, you're killing tons and tons, millions of bacteria in your body, which is why they often say you should take a probiotic because it
This is
then helps create or helps rejuvenate those bacterial cells that you inadvertently kill when you take an antibiotic drug. Like
yeah,
it
that's
just
what I'm
goes to
saying.
show
That's
like
why
the
this
silliness
reasoning
here.
is just so sloppy.
Yeah.
Like very, very poor word choice. I mean, it has. I don't know. It reeks of religious influence. That I mean, I could just like just the. I don't know his. I mean, what his personal beliefs are, or his religion or whatever. I mean, he's probably Christian, but like so some of the talking points that I hear from the evangelical right, it just reeks of that. Of what I'm pulling from this.
Yeah.
So it's using some of this some of the same sloppy language that shows that he hasn't put a lot of thought into this. This seems like something. This is a belief that he already had coming into this case, and then just apply the reasoning he had to these specific circumstances, rather than started from scratch and looking at what the law says.
Yeah, so I mean, like it just goes to show. I mean, and not to call this person ignorant, but the argument itself ignorant. Down on page 65, this is a direct quote. As we have explained, procuring an abortion is not a fundamental constitutional right because such a right has no basis in the Constitution's text or in our nation's history. End quote.
neither does equality.
Yeah,
No,
it just doesn't. Like there are things that just didn't exist in our Constitution, and that, by the way, still
civil
don't
rights.
necessarily exist in our Constitution.
Definitely not an American tradition.
Yeah,
This is pretty new,
yeah. I
right?
mean,
I'm
the
like
idea
my
of
my
equality in
grandma
general is very new.
was a teenager who's only in her 70s. Like she was a teenager, and 19 when this Brown versus Board of Education was decided.
Yeah, she
So
probably would have been early teens.
yeah,
And like this
this
is
was only
new.
6 years before my father was born.
Yeah, this is new, and this is like
Yeah.
impacting people that we all know, like that. And I mean we all as collective, anyone who might listen to this, because chances are you may have a parent or grandparent who was alive at the time that some of these laws were first being acted upon. So in both Geo and my lifetime, his father and his grandmother, especially his grandmother, she was a teenager at the time like Brown versus the Board of Education was passed into law, which reversed Plessy versus Ferguson, which had been a law since what 1895 or so.
Yep.
So
I mean, are we going to reverse marriage equality as well? Like for instance, like same sex marriage and all that kind of stuff? Because that definitely has no tradition. I mean, that just came about in what, like 2015,
yeah, I mean,
2014 or
first
something
state
like
to
that.
pass it was Massachusetts. So I mean, like they're like these are things that like are
Yeah, this is
modern.
brand new.
Yeah, these are
If
modern laws
here's
that are
also I wanted to
passed.
say, just from um I'll say this. We get ready to end soon. It's past 7. But like I wanted to
Grab a
say
page
that
while we talk about this.
tradition is really a dumb reason to do anything. Like if you had, from my experience, whenever somebody says the reason they're doing it is because of tradition, it's because they don't have a good reason. If you have a good reason, then you'll say that. You'll say, "Oh, it's it helps me achieve my goals better. You explain how it does that. If you're saying tradition, you're saying we do this because it's always been done this way.
Yeah.
That
And
shows
by
a
the way,
very serious lack of critical thinking.
yeah, it not only does it show lack of critical thinking, it also shows fundamental flaws that can come about because of it. And
Yes.
by that I mean like scientifically, historically, individually, personally, like in on any and all facets of every person's life. Because
Yeah.
let's just go to a really simple understanding of uh, something that's been pretty much all but banned in China today, and that's the idea of foot shrinking. Now, if you don't know what foot shrinking is, they would take women's feet, they would wrap them up in tight bands, and they would shove them in a tiny shoe. And they would do this for their entire lives because the idea was that smaller the woman's foot, the more attractive the woman is. And historically, they did it that way for hundreds of years. And then when you ask the reason for it in modern Chinese culture, we've always done it this way. Except now we have the wonderful benefit of medical science showing that this is really bad for people because there are people that are alive today that were subjected to foot shrinking that can't walk because that
Yeah.
it's that bad for their health and posture. And so if you want to make the argument from tradition, just look at something like that where traditionally speaking this happened for hundreds of years. But traditionally speaking, that's stupid because it caused disabilities and like otherwise regular human development. You literally
Yeah. I mean,
kept people from walking.
unless you want to argue that the founding fathers were like perfect or reached the the pinnacle of, I guess, human reasoning, it makes little sense to say we should do things because this is the way they were doing it.
Yeah.
Tradition, essentially.
Yeah, and that can be
This
applied
is
to
how
founding
this.
fathers. It can be applied to religion. It can be applied to medical science. It can be applied to
Yes.
history. Anything, literally any aspect. If
Yeah, I mean, most of if you think like the ways that America has improved the most, over the past 100 years or so, especially in regards to human rights, etc., it's been breaking away from tradition. That's that's what they've been doing, breaking away from it, and not following it.
yeah,
So
yeah, and that goes to the things from historically like African Americans. It goes to things like women's rights. It goes to things like same sex marriages. It's just breaking this mold of tradition that has been this way, and because your parents did it that way and their parents did it that way and blah blah blah, these traditions that are being broken are setting precedences that most people would agree brings us in modernity closer to equality, because I think there's not many people watching that would say that men and women should be unequal, at least as far as what rights they have are. There's not
yeah,
anyone that I would know in modern times that would say because of the color of your skin, you should get less rights or more rights than someone else. That's a person born in the same state, the same year. By the way, that applies to the two co hosts of this show. We were born in the same state. We were born the same year. We have different skin color. Should either of us have more rights than another? Traditionally speaking, I would have more rights. Should we just
yeah,
follow those traditions? Of course not. That's where you see this simple, silly argument coming about, and that's why I think both of us kind of got frustrated by it. Although you can have an opinion on the whole other matter in general and your thoughts of pro-life versus pro-choice, making an argument like this one and the opinion piece that we were talking about specifically in this episode, strictly based on uh, an argument from tradition, is just a very bad one.
yeah.
Anything you wanted to add? Anything that we missed?
No, I think we covered it all here. It's like it's past 7, but like I say, I mean, if this is still relevant next week. It probably will be. Maybe we can give it like a whole read through, and unless we decide we want to tackle something else. I mean, I'm down with coming back to this. But
Yeah, I mean, there are definitely things that we could expand upon each individual facet here. We could talk about specific things that are mentioned in here. We could talk about if there are any new developments next week, or if there's something else that you guys want us to talk about in general. Feel free to reach out, recommend us a topic, give us a shout out on Facebook, say hello, give us a comment on our videos, reach out to us, join our Discord server. Just let us know you're here. We appreciate you watching. We appreciate you listening. As I mentioned earlier, we have a Discord set up. We're also on Apple Podcasts, Google Podcasts, Spotify now. So we're trying to grow and expand. Please give us a share, a like, a follow, whatever the appropriate social media is as necessary. Otherwise, we shall see you guys next week, and we hope to see you there.
yeah, also one more thing.
Sure.
We want to hit 500 likes and follows by the end of the month. So spread the word, man. Help us reach that goal.
Yeah, please share it. We're
500.
trying to get to 500. We're a little over halfway there, and I think it's possible for us to reach that goal, and we'd appreciate your help in getting there. So we'll see you next week. Hope you have a wonderful afternoon.